Hello everyone, my name is Kirti and I am an assistant professor in ITM. Today I am going to discuss one of the major topic in business law, that is discharge of contract. So basically discharge of a contract means termination of contractual relationship between the parties to a contract. In other words, a contract is discharged when it ceases to operate, that is when the rights and obligation created by it ends comes to an end. So basically a valid contract gives rise to rights and obligation between the parties. A contract is deemed to be discharged when rights and obligation arising out of the contract are extinguished. Therefore, the term discharge means the termination of the contractual relationship. So these are the modes of discharge of contract. Number one is by performance, then by agreement or consent, by impossibility of performance, by lapse of time, by operation of law, by breach of contract. Number one is discharge of contract by performance. So discharge by performance take place when the parties of the contract fulfill their obligation arising under the contract within the time and in the manner prescribed. So basically it can be done in two ways, by actual performance or by attempted performance or tender of performance. So actually performance means a contract is said to be actually performed when both the parties fulfill their respective obligations arising out of the contract according to the terms of the contract. Now move to attempted performance. So it is an offer of performance by the promisor in accordance with the conditions laid down under section 38. This section states that if the offer of performance has not been accepted, the promisor is not responsible for non-performance, nor does he thereby lose his right under the contract. Next is discharge of contract by agreement or consent. So the general rule of law is that a thing may be destroyed in the same manner in which it is constituted. So therefore a contractual obligation may be terminated by an agreement which may be express or implied. So there are various modes which adapted in the discharge of contract by agreement. Number one is novation. So basically the term novation implies substitution of a new contract in place of existing one. Right, so here the mutual consent of the parties is required. Now move to decision. So when the parties cancel all or same of the terms of the contract by mutual consent, it is called rescission of the contract. Right. Now move to alteration. It occurs when one or more parties of the terms of the contract are altered by the mutual consent of the parties to the contract. Alteration may be bilateral or unilateral. The difference between the novation and alteration is that the novation may result in change in the terms or change in the parties, while in case of alteration, the parties remain the same. Therefore, the novation is a wider term than alteration. Then move to remission. So it means the acceptance of a lesser performance than what was contracted for. Accord and satisfaction is one of the ways in which a contract gets discharged under English law. When the promisee accepts lesser sum than what is due under the existing contract is known as accord, and the actual payment made by the promisor is the satisfaction. Now move to waiver. So when a contractual party fails to perform his obligation under the contract, the other party may resign the contract and may waive the promise or release. This is called a waiver. So it takes place when the parties to a contract agree that they shall no longer be bound by the contract. Now move to merger. So merger takes place when an inferior right accruing to a party under a contract merges into a superior right accruing to the same party under the same or same other contract. Here is the example is also given. P holds a property under a lease. He later buys the property, so his rights as a lessee merge into his rights as a owner. Now move to discharge by impossibility of performance. So it is under section 56. Impossibility of performance may fall either of the following two categories. Number one is impossibility existing at the time of agreement. So basically an agreement to do an act which at the time of the contract is impossible in itself, such an agreement is void. It may be known to the parties, like for example agreement to make the dead person alive, or second is unknown to the parties at the time of making the agreement. For example, in bilateral mistake as to existence of the subject matter when both of the parties simultaneously do the mistake, that is called bilateral mistake. So here is the impossibility in on the initial stage. Now move to impossibility or on subsequent basis or post contractual impossibility. So contract to do an act which after the contract is made become impossible, unlawful, becomes void when the act become impossible or unlawful. In such a case, both the parties are discharged from their respective obligation. For example, A and B contract to marry each other. Before the time fixed for the marriage, A goes mad, so the A become incompetent, and incompetency is not allowed in the law. So in this case, the contract becomes void. Now move to discharge by lapse of time. So basically the Limitation Act 1963 lays down that a contract should be performed within a specified period called period of limitation. It is not performed, and if no action is taken by the promisee within the period of limitation, he is deprived of the remedy at law. In other words, we may say the contract is terminated. Let's suppose X buys Voltas air conditioner on credit basis from Y, where the price is to be paid after 1 month. If X fails to perform his obligation and Y doesn't institute a suit against X for the recovery of the price within 3 years, the contract terminates by lapse of time, because according to Law of Limitation Act 1963, the period of recovering the amount or to sue the debtor is given is 3 years. So after the expiry of that period, the court debars the promisee from taking the legal action. Therefore, the lapse of time discharges a contract. Now move to discharge of contract by operation of law. So a contract may be discharged by operation of law which take place by death. Like in contract where personal qualification of the promisor such as skill, knowledge or ability are the consideration for the contract, and in such cases contract need to be performed in person, the contract stands terminated on the death of the promisor. Now move to insolvency. So when a person is adjudged insolvent, he is discharged from all liabilities incurred prior to his adjudication. So basically, an order of the discharge releases the insolvent from earlier obligation. Upon insolvency, the rights and liabilities of the insolvent are transferred to the official assignee or official receiver, an officer appointed by the court. Now, by unauthorized alteration of the terms of the written agreement, so unauthorized material alteration result in termination of the contract. Material alteration is one which varies the rights and liabilities or legal position of the parties to the contract, that is alteration of the amount or rate of interest. Non-material or authorized alteration doesn't affect the validity of the contract. Now move to by rights and liabilities becoming vested in the same person. So when the rights and liabilities under a contract vest in the same person or other parties are discharged. Now move to discharge by breach of contract. So basically, when a party to the contract without lawful excuse fails to perform the obligation imposed upon him, he is said to have committed breach of contract. In case of breach of contract, the injured party has the right of action for damages against the defaulter party. Breach of the contract may be of two types: actual breach of contract and anticipatory breach of contract. Now move to actual breach of contract. So actual breach of contract may take place when one of the parties fails or refuses to perform this obligation, either number one at the time when performance is actually due, or second is during performance of the contract. It may be occur expressly or impliedly. Let's suppose I take an example. A agrees to deliver 500 cell phones to B on 1st of July. He doesn't deliver the cell phones on that day. So there is a breach of contract by A on the due date. Now move to anticipatory breach. So when a party to a contract resigned or renounces his obligation before the date of actual performance, breach by him is termed as anticipatory. So when a promisor fails to perform his obligation and the promisee condones his breach of contract or waives his right, the contract continues. In such a case, innocent party is entitled to claim compensation from the party in default. So anticipatory breach may take place in two ways. Number one is by express renunciation and second is by implied renunciation. So by express renunciation means when the promisor informed the promisee expressly before the due date of the performance that he will not perform his obligation. Let's suppose a principal employs A as his agent with effect from 1st of March. On 25th Feb, he informs him that his services will not be required. So this is an anticipatory breach of contract by express renunciation. Now move to implied renunciation. So in this case, the promisor by his own conduct renders the performance impossible. Here the party does something which indicates his intention not to perform the contract. For example, A agreed to marry B on Akshay Tritiya. Before this date, A marries C. Here A's conduct has made the performance impossible. So this is an anticipatory breach of contract by implied renunciation. Right. So that's all for today. Thank you so much.